Cool. Now, your question comes from a landlord. And unfortunately, is one of those situations, especially over December, that we see a lot of, where unfortunately people go on holiday, including your rental agent, and issues start falling between the cracks, right? And in this situation, what happened was the tenant had an issue in one of his units, and he reported it as they normally do. They've got systems and it's a great login platform. They reported it, and the person issued a ticket to appoint a service provider. Again, all done, it's automation, it's all great. Confirmation was received. Apparently, the ticket went out. The service provider did not attend the property, right? Now, this is a problem, right? Because it was a serious incident and it did cause damage. It did cause damage to the tenant's property. Now, the tenant sent a letter saying that he wants to cancel the lease agreement based on the breach of the lease agreement. Now, in layman's terms, he said breach by the letting agency, but we both know that, or actually you can explain how that would work, how the connection would be made. However, he wants to cancel the lease and he basically suffered damages. Now, the landlord wants to find out, are they entitled to cancel the lease? It wasn't his fault. It was the letting agent's fault. It was actually the service provider's fault. How does this all come together?
Perfect. So let's go from the very beginning and deal with our basic contract law, which we've done many times, but it absolutely warrants re-saying, especially in a question like this. So a lease agreement is an agreement which is concluded between the tenant and the landlord in the circumstances. Those are the primary parties and the only parties that are party to this agreement. And it bears reminding because very often we see in the industry, people are not doing this as their daily thing. And so there's often confusion about who are the parties to the agreement. And we often see lease agreements where the agent has been included as a party or there's a place for them to sign. But the way lease agreements work within our law is there are only two parties to this agreement, and that is the landlord and the tenant in the circumstances. Now, these parties are perfectly entitled, as anyone is entitled in our law, to acquire the existence of another person and appoint them as an agent to act for and on their behalf. Okay, this is obviously very common for landlords to do in the circumstances to help them facilitate and administer their properties. Okay, but the principles of agency can be undertaken by anyone. Okay, anyone can appoint an agent to work on their behalf. Okay, and you can get them to do things for and on your behalf in the circumstances. So the one thing you need to know about agency is when you are giving someone a specific mandate of agency, an ability to do something on your behalf, you need to be very aware and very careful about how you give them that mandate and what you give them a mandate for. Okay. When you appoint someone to do something on your behalf, to perform a certain function on your behalf, you ultimately also accept the consequences of them doing that particular thing for and on your behalf. Okay. So you need to be very cautious about appointing an agent. Make sure that when you do appoint an agent, when you appoint someone to perform a certain function on your behalf, understand that the consequences of them doing something will come back to you ultimately. And make sure you are appointing someone to do something on your behalf that you know is going to perform properly and do the functions properly. And I don't mean to fearmonger about it, but it does play a consequential thing in this particular circumstance. So in this particular case, we have landlord tenants. As I said, they are the parties to the lease agreement. The landlord's appointed an agent. Unfortunately, given the time of year or whatever the case is, the agent didn't manage to perform a certain function. And as a result, we've got a tenant who wants to cancel their lease agreement. Now, can the tenant cancel a lease agreement? Entirely depends on whether the landlord has not done something that they are supposed to do in terms of the lease. They've not maintained the property or whatever the case is. And that constitutes a material breach of the agreement. There may be an opportunity for them to cancel in the circumstances. Again, remember, if you're going to cancel an agreement, you need to look at the provisions of the lease agreement and at least place the opposing side in what is called mora. So mora is just a term we use to say you're in breach. You give the other side to a contract an opportunity to remedy the breach within a certain time period, and that will depend on what the breach exactly is in the circumstances. But if that's not actually remedied, you are in a position where you can cancel the lease agreement. This is very common, obviously, for landlords who haven't received their rent. We do a demand, you place the tenants in what's called mora, and you cancel if they don't remedy. But the tenant is perfectly entitled to do exactly the same thing to the landlord if the landlord doesn't perform their functions. So the tenant might be in a situation, absolutely, if something hasn't been attended to, they place the landlord in mora, they will be entitled to cancel in the circumstances. Now, the question then from the landlord is, well, if that does happen, my agent hasn't done something and the tenant now wants to cancel, what do I do? So unfortunately, you're absolutely in a circumstance where you're going to have to deal with the fact that there's a cancellation by the tenant. Then the question is about the performance of the agent in the circumstances and whether they were negligent in their duties. Did they not perform the duties that they were supposed to, that they were mandated to in the circumstances? And depending on how the agent acted or omitted to act in the circumstances, you obviously are in a position where there might in fact be a damages claim against the agent. What the question here is, whether there's been a breach of the contract that you have with your particular agent. So if you appoint an agent, you have an individualized contract with the agent. The landlord and the agent have their own contract. And if they don't perform the functions that are required in terms of that contract, it in itself is a breach of contract. And there might be damages stemming from that particular contract. So to sum up sort of the whole question, is there an ability for the tenant to cancel even though it's the agent who failed to perform the functions in terms of the lease agreement? Yes, absolutely. Unfortunately, the agent is the one who's responsible to perform the functions on the landlord's behalf, if that is in fact a duty which has been passed on to the agent. Their failure to do so means that you have failed to do so because they are your agent in the circumstances, so the tenant can cancel. What are the consequences of that? If there is a breach of the contract that the landlord has with their agent, they may be entitled damages in the circumstances, and that would be a claim simply between the landlord and the agent, which they will need to sort out.
Thanks so much, Nick.
Perfect. Thank you, Bruno, and
Cool.
we will see you next week.
Have a great one.
Perfect. All right. Cheers.
Cheers.